So I've sent a link to a lot of people who asked for it.
Yeah.
See if it works now. And if not, we have enough people to, if you agree, start in 2 minutes. In the meantime, let me introduce you to some people that are in Marikee. You see your friend Julieta, and Julieta is, along with Alejandro Flores and Paula Aldrete, we're all members of the same committee that we chair the committee of the Mexican Bar Association. And when I was asked to chair it, I told the president, Claudia de Buen, that I wanted to have a gender balanced and very specialized and fun team. So I got my pick. I got 3 people who are excellent persons, who are true arbitration experts, and a young one, some like me who are older, and so we're balanced in every way possible, and it's been fun. So
and glamorous and artistic and nice and everything.
Exactly, well put. So and Alejandro, Paola, and Julieta. Well, Julieta doesn't need to be introduced you. This is Marika Pulson. You've obviously heard of her, so it's great for me. I'm glad to present you all.
Hi, Marika. It's a pleasure for me. I am the fun part of the team.
Nice to see everybody.
I'm not the old one like Francisco.
No, I'm the old one, the only old one.
Fernando,
How are you, Marike?
Hello, how is everybody? How are you?
Hi, Fernando, remember to talk about age, please.
And the reason, Marike, Carlos Loperena has your name in his picture is that I gave them the link that you're using because they were having problems accessing.
You were also my name. I saw it.
Yeah, I did the same thing. And you know also, well, you probably know Carlos Loperena is one of our top practitioners in arbitration in Mexico, also a very senior arbitrator. We have Jorge Ogarrio here, who's a very active arbitrator in Mexico and who's the former president of this commission. So I thank Jorge for being here. Antonio Prida, you see him. He's our mentor in mediation and alternative dispute resolution. He chairs the ICC committee on the topic, and he's currently our voice in the Mexican Congress to have an intelligent legislation and adopting the Singapore Convention, which is being troublesome for reasons I won't get into unless you ask. But and
I'm going to talk about it briefly. So
great. I see also Luis Santos, an active practitioner in Mexico. And if you agree, it's 8:40. We've given 10 minutes. And if as agreed, if you would like, I'd like to give the floor to Héctor Flores to give us the noti arbitraje, the espresso on a topic, and then present you appropriately, Marika, if you agree.
Great.
Héctor, the floor is yours.
Thank you very much, Francisco. I'm glad to be here with you this morning. Glad to see your faces. And thank you for this opportunity. I was given 5 minutes to talk about a subject, and the one I chose has to do a little bit with the New York Convention. One of the 2 purposes, as you know, is the enforcement of the arbitration clause. And the transcendence of this topic to me is obvious because the agile referral to arbitration and the absence of restrictions that complicate its development is a very important topic for us as practitioners and users of arbitration. So it's an old topic, but it still creates problems in practice, at least in Mexico, and that's what I want to talk about. The enforcement of the arbitration clause, as you know, is also tied to the competence principles, because having presented a court action that presumptively falls into the scope of the arbitration agreement, it should not, in theory, be sufficient to merely argue that the arbitration clause may be invalid or null, to avoid not only referral, but also to avoid the arbitrator having to deal with this issue and placing it only in the hands of the courts. So in principle and in theory, or so have we been told, Article 1424 of the Code of Commerce, just as it is drafted, which, as you know, is not It's not a Mexican creation, but it's based ultimately on what is in Article 2 of the New York Convention. This should solve the issue. However, in 2006, the Supreme Court did not understand it this way. In a binding precedent, this is jurisprudence 25, 2005, which was very criticized by Mexican arbitration practitioners and commentators, resolved in essence that the exceptions foreseen in Article 2 of the New York Convention, Article 1424 of the Code of Commerce, are in reality exceptions to the competence principle. Now, the legislator, in theory also, tried to amend this mistake in 2011 and amended the Code of Commerce. It created, among others, Articles 1464 and 1465 of the Code of Commerce, which explicitly deal with the referral to arbitration and the way it should be implemented in light of what is provided in Article 1424. Now, for some of us, and we may be mistaken for what I've seen, but some of us think that what we find in Articles 1464 and 1465 already solved the issue created by the jurisprudence of the court in 2006, and that is preserving all the effects of the competence principle. Now, the problem I want to present is that in spite of this amendment, some courts, some practitioners really doubt and consider whether Article 1424 can be read and understood without reference to what is provided in the rest of the articles. And in particular, the compatibility between the precedents, the judicial precedents that were created before the 2011 amendment and the Articles 1464 and 1465. Now, I want to report, excuse me, two decisions. One is a district court decision. By the way, I provided these judgments, which are public, of course. I provided them to Francisco already. I'm sure we can find a way to distribute them among you if you're interested. But in this first decision in 2019, this court denied that the 2011 amendment had changed the regime created in Article 1424 of the Code of Commerce and sustained the applicability of the jurisprudence of the court in 2006. So based on that premise, it was enough for the claimant to argue the invalidity of the clause, to deny referral to arbitration, and to reserve the jurisdiction on this topic to the court. This case was a bit extreme because on top of this, the court also granted interim measures to suspend the arbitration. Now, in a fortunate contrast, in July last year, the Supreme Court of Mexico resolved another issue regarding Article 1424, and that is at what time in the proceedings may the respondent ask for the referral to arbitration. This in theory is an obvious question because Article 1464 already deals with the matter. But a federal court found a way to deny the effect of this article based on a wrongful, in my opinion, a wrongful interpretation of Article 17 of the Mexican Constitution, which, as you know, already incorporates arbitration and other dispute resolution methods to the constitutional order. So the Supreme Court in this case not only amended or not only corrected the federal court in this regard, but also determined that the precedents revolving around Article 1424, in which the federal court was based, were no longer applicable in light of the 2011 amendment. So the court really saw the issue and gave effect to the legislator's intent in 2011. So these are the two decisions I wanted to talk about, and they may refer to an obvious topic for most of us, probably. But I find it relevant because there are some things that may be evident for some of us, and that perhaps were also obvious to the legislator back in 2011. But the fact of the matter is that some courts and some litigants are not in agreement with this view. So regardless of your opinion on this, I just wanted to catch your attention to these topics, and I hope you find them interesting for whatever reason. So thank you for this opportunity, and I'm glad to be here with all of you. Thank you, Francisco.
Thank you, Hector. If somebody has a comment, they'll be welcome. Just, I would ask that they be brief. And just to give a quick heads up about what Hector is saying, it's unfortunate that we have those precedents. Marika, the precept that Hector is referring to is the Mexican domestic law equivalent of Article 2 of the New York Convention, and it's the effect negative of the arbitration agreement. There was as Hector reported, there was a 2006 bad precedent in Mexico, which said the same thing at the same time for the same reasons as Buckeye cashing in the US. So as Hector indicated, many of us criticized it, and there was the only single time we've modified our law was to cater to this. And ever since, I don't know what other people's experience is, but I've always been, in every single case I've asked for referral, that the judiciary has been very, very good at referring parties to arbitration, even in tough cases. What Hector is pointing is therefore unfortunate because it's the improper reading of the two articles. And perhaps, I don't know if Carlos and Victor and Jorge agree, and Julieta, obviously, that we should present this to the IMA or perhaps even this commission and do a statement, a postura about the proper interpretation of that precept.
Of course. I second that motion, Francisco.
Okay, any comments by anybody?
And even this position that you suggest that the IMA takes and this commission, we could do it jointly and maybe with other arbitration institutions, because there are people here who belong to other Mexican arbitration administrators, and it could be nice or proper or interesting to join all forces to have a common position and not only one or two of the institutions involved.
Thank you, Carlos. I take note of that, and the commission, Julieta, Paola, and Alejandro and I will talk about it and see how we implement it, if you all agree. Okay, having done that, and thank you for keeping it brief, Hector, let me give the floor to our main dish of today, and I will ask Julieta to present Marikee Pulson, not before just abusing a bit of the microphone and saying that one of the nicest things about Marikee is not only that she's a terrific person and she's very interested and lots of fun, but she wrote this book. I don't know if you can see it well. One second and you'll see it well. And mind you, Marikee is not paying me royalties to say this, even though she probably should. But this is, in my opinion, one of the best books on the New York Convention that's been written. And it's a nice sequel to the Locus Classicus, which is the Vandenberg treatise. And Albert Jahn is Marikee's mentor, as I understand it. And the fact that Marikee took up the ball 25 years later or so and wrote a second part as to what happened with the New York Convention 25 years later is something that I find fascinating. I honestly think that alongside the Vandenberg treatise, one should have this second book too, to see what's happened in those 25 years. So having said that, I will give the floor to Julieta to present Marikee and obviously give the floor to Marikee. Thank you very much.
Thank you, Francisco. I'm not paid also any royalties, but you know, you should have this book. I have it here with me all the time, and it's excellent. So it's my pleasure to introduce a very dear colleague and friend, one of the most extraordinary women I've met, extraordinary and complete women I've met. It's such a pleasure to have you here, Marikee. Marikee Pulson, based in Bahrain, is a senior advisor at ASG, where she draws on her extensive experience in public international law, international arbitration, human rights, and cross-border litigation to advise clients on resolution of investment and commercial disputes with states through global strategy and commercial diplomacy. Ms. Paulson also served as the director of the University of Miami School of Law's International Arbitration Institute and is a professor of international law. She's a leading expert on treaty compliance by states and the of course, the 1958 UN Convention on the Recognition and Enforcement of Foreign Arbitral Awards, the New York Convention. And she often briefs judges and policymakers around the world on the treaty through constructive dialogues. Ms. Paulson is the Vice President of North America of the Global Institute of Peace for Peace Studies of the University of Sao Paulo. She's also an appointed member of the Court of the Mauritius Arbitration and Mediation Center, a member of the Judiciary Committee of the International Council for Commercial Arbitration, and a member of the jury for the Princess Sabiga bint Ebrahim Al Khalifa Global Award for Women's Empowerment, which is awarded by United Nations Women and Bahrain. Earlier in her career, Ms. Paulson served as counsel at Hanotu and Vandenberg in Brussels and held associate positions at Freshfield Brookhouse Deringer and Allen Overy in Amsterdam. Ms. Paulson graduated from Leiden University School of Law, holds an LLM in International Law from the University of Miami School of Law, and has a diploma from SIPO Paris, where she studied political science. Well, Marika, you are very, very welcome. We are very, very happy to have you here. You have the floor.
Thank you. You both just made me blush. And thank God it's not visible with all the patterns that go on my side of the screen. I think COVID started in 2019. We're in 2021. We've all been zoomed out. We have received Zoom tips and Zoom training. And number one advice is make sure you have a calm background. And me being the rebel without a cause, I've decided to do the exact opposite, because why would you want to follow, the masses? So I have prepared something for about half an hour, but I can stop earlier. I can go on longer. If anybody has questions, I'm entirely flexible. When Francisco and Julieta asked me to give this lecture or speech, it goes without saying that I said yes immediately. Not so much because I enjoy talking about the New York Convention all the time, but you are my friends, all of you on that side of the screen in Mexico. I visited Mexico a couple of times. We've had so much fun and adventures, including earthquakes. Another dear friend of mine, Beatriz Paredes, a fellow Mexican whom I admire greatly. So it's a wonderful place to be, and an incredibly impressive group of lawyers, an incredibly impressive arbitration community. And it's just really nice to be part of it, even remotely and from the sidelines. So there we are. Now, indeed, I wrote a book on the New York Convention, and I teach on the New York Convention, and indeed, having worked with Albert Jan, you sort of need to know a thing or two about the New York Convention. So it will be very odd that the two people who spent quite a lot of time studying this topic are also the two people who say it's time for a new treaty. And so Albert Jan van den Berg did that in 2008. And he has continued that journey ever since. And I must say that I too have become quite cynical. Maybe the old adagio is the more you know that you know nothing, and the more you know about something, the more you know that in fact it's a total disaster. So that is the theme of my little speech of today. So that's why I called it the New York Convention towards 100 years. Indeed, ageism is a very bad thing, especially when a lot of people in our community are properly over 40. But when it comes to this treaty, I am going to be the guilty one and introduce a fair doses of ageism into this discussion. I think that the New York Convention is too old at 60. And I don't think the New York Convention should go on beyond 100. I think that for the next 10 years, we should have a plan, sort of a 10-year plan to go to the next phase. I think it's ready. I think it's ready to say goodbye, which I do entirely out of, or not, or how should I say it? I'm hurting myself or my own business, because it means that my book, and I'm supposed to write the second edition, I think this year and next year, will be useless, because then there will be no more New York Convention. So you see what I'm doing here. Now, I love to, as Julieta knows, tie the law to the artistic and to the arts. And so there is this artist called Michelangelo Pistoletto who makes this artwork that is based on the infinity of the past, present, and future. So it's 3 circles that are all connected. And I love that theme for the law because without the past, we cannot look towards a future. And so today we are in 2021. It's the 1st of September. The world is slowly processing the deadline of the 31st of August, which was yesterday. I think many of us are still trying to help and play some role in the humanitarian crisis that's still unfolding. And so that is 2021. We are in geopolitical turmoil. We are perhaps not in a World War II, but we go from global wars on terror to the global war against this pandemic to climate change. And I think it's safe to say that in my life, and even that of my mother, we find ourselves at a unique crossroads in history. Now, why do you wonder, among lawyers, why am I talking about history and politics and geopolitics? Well, I work at Albright Stonebridge Group, which is led by Secretary Madeleine Albright. So, you know, when in Rome, do as. And the geopolitical is very much tied to the position of the New York Convention worldwide. So let's go back to the past. What many people do not know is that the New York Convention is really a product of the 1920s. The New York Convention is very much a reaction to the Geneva Conventions of 1923 and 1927. So for maybe the youngsters, so maybe the Young Mexico arbitration group, it did not start with the New York Convention. We had a protocol and a treaty for the recognition of arbitration agreements and enforcement of awards. And what happened in the 50s, right after World War II, is there were modern businessmen who said the Geneva Convention is outdated. And this all started, in fact, and I'm not sure if you know, it started with the ICC. So there is the representative of the ICC in 1951, Mr. Haight, who went to a conference and said, we need to have something else. We need to replace these treaties. And that was the beginning of this journey that went from the ECOSOC to the United Nations in New York. And in 1958, there we have it, the United Nations Convention for the Recognition and Enforcement of Foreign Arbitral Awards, also known as the New York Convention. And what followed is 60 years. 60 years, I think now we are getting close to 170 contracting states and thousands of decisions reported worldwide in the ICA yearbook. So I guess that's a success. Is it really? 60 years went by in the blink of an eye. The father of the New York Convention, also a Dutch person, by the way, Piet Sanders, bid the world adieu in 2012 at the age of 100. So I guess arbitration keeps you young. And so we are all in awe of this brainchild of Piet Sanders. And in a way, we've been taught or told or hinted at that we should not touch the brainchild. And I just wonder why. Why is it that when people like Albert Jan suggest a replacement, it's outrage that follows? Why is it that when we suggest, for example, to stakeholders at UNCITRAL to consider an amendment, a new treaty, that the rebuttal is, this is just too complicated? I wonder. So what I want to do today is, I would like to sidestep. Okay, so what we do is we check in with ourselves, you know, we're all into mindfulness, and we take a step back and we look at where we are today. I think there are 3 camps in the world of the New York Convention. One is the status quo camp, which is keep as is. If it ain't broken, don't fix it. The second camp is the minority, which is replace it. And I believe there are maybe two people and then some. And the third is those who believe in the unicorn treaty. And that is, let's just look at this New York Convention that is like the United States Constitution, which is a Swiss cheese filled with holes. And I hope you can still hear me because I hear some other voices, or maybe I'm just hearing them in my head. Okay, excellent. So the Swiss cheese document is now apparently one that we can use for a world court that is going to be created at the UNSTO Working Group 3, a world court that is going to deal with all investor-state dispute settlement cases, and any judgment that is rendered by this court can be enforced by the New York Convention. And then these unicorn treaty followers also believe that the New York Convention twin, which is the Singapore Convention, because mediation is the future. And because mediation is the future, let's have a treaty for the recognition of those mediation decisions. And why reinvent the wheel? Let's just copy the New York Convention. No lessons learned have been implemented in the Singapore Convention. We just keep it as is. So there we are. We now have a treaty that is not 60 years old, but like a little toddler that has to deal with the exact same problems that serve us under the New York Convention. So those are the three camps: status quo, the minority for replacement, and the followers of the Unicorn Treaty. Okay, that's law. Now I want to go back into geopolitics, because this treaty is, one, all about politics internationally, and two, it's all about domestic governance. So where are we? It's the 1st of September, 2021. We had Trump, and I'm very careful because I'm virtually in Mexico right now. We had Trump, then we had Biden. Needless to say, delighted, half my firm is gone because they're all in the Biden-Harris administration. We have, over the last 10 years, what have we seen? What have we seen? In technology, we've seen blockchain, which I guess I know something about it because I'm on a board for blockchain arbitration, but if I would have to explain to my son what it is, I would be utterly lost. We have artificial intelligence, we have virtual reality, we have social media. Apparently we can be tracked through social media. We have the battles of Apple and Steve Jobs, Facebook, Zuckerberg, and God knows what is going to happen tomorrow. And we're thrown into this virtual world through the pandemic, where I think for the first time in my life, I have high levels of anxiety, being terrified that my internet just is my oxygen lifeline that can drop at any given moment. And I'm just praying here. I have all this instance now because I feel it's more reliable than my router. Then what else do we have? We have a pandemic. And when this started in February 2019, I think we thought practically, okay, we have to just try to manage, try to stay safe, maybe until the summer. Now it's August 2021, and here we are, and the world has changed. And finally, we come to terms understanding that this is the new normal, that we are not sure if we're ever going to go back to whatever it was before. It has changed the way our children are growing up, the way they are educated, but also the way we handle our matters in international arbitration. And governments, I mean, governance has been put to tests like we could have never imagined. And then we have climate change, something that now has found its way in new model bilateral investment treaties. And then we have the geopolitics of politics, and the world has become more political than ever. Now let's go from that geopolitics into how that sort of trickled down into this wonderful little bubble of the law, and more specifically arbitration. Post Elizabeth Warren and Trump, we saw how it affected TTPs, CETA, USMCA. I'm again looking at my friends. I remember participating in meetings with the NAFTA 2022 committee in Washington. May it rest in peace. We have new model BITs from India and my country, the Netherlands, holding investors accountable, adding sustainable development goals from the United Nations, actually wanting to get rid of ISDS. We have the ISDS reforms that I mentioned before at the Working Group 3. So basically, we are faced with a PR crisis of international arbitration, and perhaps more specifically, investor-state dispute settlement. So there we are. The last decade caused more turmoil than ever in our little arbitration bubble. And so I think that we must accept that we don't know what international arbitration is going to look like 10 years from now. It will look different, might be a lot more than a Kim Kardashian facelift. We might just have mediation. We might go back to domestic courts. We might see ourselves with commercial diplomacy. Maybe we just actually do need to find a different career path. We do not go along with this pace fast enough. We don't like change. This explains our resistance, for example, to mediation. Now, mediation is something that we find difficult to embrace, which is interesting because Pete Saunders in 2000, what was it? I think it was 2010 that we asked him, what is the future of arbitration? And he said mediation, which is interesting because it's now 2021 and here we are. So he did have a little crystal ball and predicted the future. The other question I received the other day from Brazil is artificial intelligence. What if an award is the result of artificial intelligence? Can that award be enforced under the New York Convention? Well, you already lost me at artificial intelligence, so I have yet to answer that question. And then I mentioned it before, we are here connected through Zoom. Hearings are conducted over Zoom. Everything is being done over Zoom with I don't know how many consequences, also in terms of due process and God knows what have you. Yet, even last year, our community continues to just celebrate the New York Convention as the biggest success in international arbitration of all times, to the point where some stakeholders in Europe feel that the New York Convention even deserves a Nobel Peace Prize. So there has been an effort of arbitration specialists in Europe trying to see if they could nominate Ika and Pete Saunders for a Nobel Prize, maybe not the Nobel Peace Prize, but a Nobel Prize for the work that he has done for the New York Convention. Because at the end of the day, we are all delusional on mushrooms. So let me just ride along on that wave of hailing the New York Convention. 170 states, 60 years old, thousands of decisions. Most decisions are focused on the recognition and enforcement of awards, enforcement requests that have been granted by national courts. So the bottom line is that in those 60 years, in those 170 contracting states, of all of those thousands decisions, the vast majority is an enforcement of the award. The vast majority is a result of courts stepping back, accepting international arbitration and saying this award needs to be enforced wherever the assets are. And that is the success in international trade. And that was something that the Secretary General of the United Nations, Kofi Annan, referred to, that it might be one of the most important instances of international legislation in international trade. Okay, so I did that right along. Here you are, it's great. I think it's a fallacy. I think we cannot say that the New York Convention is the most successful instance of international law. Now, if I would be teaching right now, I would ask my students, why is that? In my humble opinion, it's because at the end of the day, the New York Convention is not an international instrument. It's not. Those who think that the New York Convention has something to do with international arbitration, in the sense that if you have to learn about international arbitration or you're teaching about international arbitration, in the same breath you can teach about the New York Convention. No, this is not true. And those who think that you need to understand the New York Convention in order to be a successful international arbitration lawyer, this is not true. Most lawyers at Freshfields will act as counsel in international arbitration. They will prepare statements, they will prepare oral arguments, they will do cross-examinations. But when the award is rendered, they sign off. It's actually often litigators, trial lawyers who go to court and who are domestic lawyers specialized in domestic litigation, not using a treaty, they use a national act. For example, in the United States, they use the Federal Arbitration Act that has implemented the New York Convention, and it is part of national law. And it is not international adjudicators or arbitrators or the judges on the International Court of Justice looking into this treaty. It is national courts, it's domestic judges who will have to deal with a request for enforcement under a national law that resonates far, far, far away as being the New York Convention. And so this is why it is so hard to talk about the New York Convention. This is why it's so hard to talk about what is Article 2. This is why it's so hard to talk about what is public policy. When should an award not be enforced? Because what we're looking at is national laws. What we're looking at is the complexity of national courts. We're looking at the public policy of the country where enforcement is sought. We're looking at due process of the country where the arbitration took place, or we're looking at due process of the country where enforcement is sought. The magic words for the New York Convention is look locally. And so when we look locally, and this is why I started with geopolitics, when we look locally, we are faced with sovereignty. And Fali Nariman, the legal legend of India, said, sovereignty, and I've said it many times, it's like billiard balls. They collide often, but seldom do they go in the same direction. Now, today, that's a euphemism. Today, where we are in terms of geopolitics, politics, governance, we're not looking at billiard balls anymore. It's far, it's like ping pong balls that are shooting in all directions. So how can you take all those ping pong balls together and say, this is what it is? This is the rationale of the New York Convention. This is how we have to read Article 2. This is how we have to look at Article 5. It doesn't work anymore. So what we now see is the New York Convention in the national space being fragmentation on steroids. So this is what I want to do, since I'm throwing in 60 years of the New York Convention towards the next, well, I think 10 years, that's my prediction. It's a lot to digest. So I want to give some things that are not so much takeaways, but taking it forward, things that we need to park on our desk and talk about and think about. And that's the following. One, I have 4 points. One, the Singapore Convention. I do think, as Pete Saunders said, that although we are reluctant to embrace mediation, although there are still a lot of hooks and crannies and things that we haven't figured out, what I've seen with my work with my firm, with Secretary Albright, is that there are many investors and users in international trade who would like to see some alternative method of dispute resolution, who look at arbitration as a last resort, who will say, I cannot go to my board with arbitration because arbitration is not a strategy. So whether we like it or not, we need to re-educate ourselves. We need to understand mediation. We need to make sure that institutions start training mediators, and we need to persuade users how to use it. And in comes the Singapore Convention, because that is the enforcement mechanism for mediation decisions. But the sad part is that it's very much a copy of the New York Convention. So then we need to have guidelines and interpretation mechanisms to at least interpret the Singapore Convention correctly from the get-go. Second, we need to look at the limits of the New York Convention as the New York Convention stands today. Now, what do I mean with this? I think we are crossing a line when representatives of the European Union say, we assume that if there is a world court for the for rendering decisions, I'm choosing my words carefully, for rendering decisions with respect to disputes between investors and states, we think that the New York Convention is applicable and that those decisions fall under the scope of the New York Convention. I think that that is dangerous territory, and if one would study the drafting history of the New York Convention, this is simply incorrect. Second, the question of artificial intelligence decisions. The minute one would say, sure, just slide them into the scope of the New York Convention, we're opening the floodgates. This is not what the drafters in 1958 had in mind. And we cannot say that this is a living, breathing document and make it so flexible that things that are unimaginable, like artificial intelligence decisions, could be enforced under the New York Convention. This is, in my view, taking it a step too far. Point 3, we need to start assisting the New York Convention with what is out there in the modern world. And with that, I'm looking at blockchain technology. Blockchain is very useful because it's a server that can store data, protect it, secure it, and never lose it. Why is this so relevant? It means that arbitration agreements, the originals, can be stored there. Awards, the originals, can be stored there. It can be certified, which means that all the problems that we see under Article 4, how do we get an original agreement? How do we get the award? How do we get the copies? How do we authenticate it? How do we certify it? This has been the Pandora's box of the New York Convention. The blockchain would solve all those problems. And then point 4, Article 2 and Article 5.1e, these are the articles that no longer hold up. And we can be in full denial, but this is simply the truth. If we look at agreements, if we look at contracts, if we look at e-commerce, right now, there are really not many arbitration agreements that are concluded the old-fashioned way. And no matter how creative we get, at some point, the in-writing requirement of Article 2, subsection 2, simply has not been complied with, period. Then we have virtual hearings. We're going to have new types of awards. Due process will be addressed in an entirely different way. So what does that mean for Article 5.1b? What does it mean for Article 5.2? And then the third, this is Article 5.1e. Years ago, after Cromwell and Hill Martin, the leading authorities would say, Article 5.1e, the debate is moot. We no longer have to talk about the enforcement of annulled awards. It's theory, it's fun for students, it's fun for professors. And then came UCOS and my Mexican friends, then came Pemex, and then came a lot more. And here we are. The discussion has been reopened. And so I don't think that we can rely on judges in domestic courts to just find solutions for all the problems that are now coming up under Article 2 and Article 5. So those are the 4 points: Singapore Convention and mediation, the limits of the New York Convention, helping the New York Convention with blockchain, and facing the reality when it comes to Article 2 and Article 5.1e. Now, what I think we should do, and this is where I go back to the beginning, which is replacing the New York Convention. I think that after 60 years, when we check in with ourselves in that moment of mindfulness, it's time to say that of the New York Convention, what is left standing is Article 3, the core. Article 3 instructs the contracting states of the New York Convention to make sure that their organs, the judiciary, their judges, will recognize awards as binding. This is that presumption that courts of those countries have to say, we're stepping back. We are no longer hostile towards international arbitration. We are accepting international arbitration as something useful in international trade, and we will recognize these awards. And with that, I quote Judge Jordan. Actually, Julieta was there on that panel at Halloween where we were all dressed up. Where Judge Jordan said, we're not here to grade papers. So if users of international trade want arbitration, that's what you wanted, that's what you wished for, that's what you're going to get. We are stepping back. And I think that is the core of the New York Convention, and that still stands, and that's still a very powerful article. And then there's Article 7, which is really the opt-out, which is anything that's more favorable is great. But I think all the other articles, they have just crumbled. They are no longer adequate for 2021 and beyond, let alone to say that the New York Convention can make it to 100. So that's my bold suggestion, to look at a new treaty 2.0 that only keeps Article 3 and 7, that faces the reality of Article 2 and 5, and that focuses on a philosophy of international arbitration where the sovereign organs, where judges step back, where judges don't grade papers, but that's it. That is it. And in order to get to that Treaty 2.0, that really has sort of two pillars, Article 3 and 7, we need to do something else. It's been discussed by myself, it's been discussed by Albert Jan, which is, and this comes the shocker at the end, to abolish national setting aside regimes. And I'm very mindful that I'm with the Mexican audience. I'm obviously mindful of Pemex, but really there are so many flavors of ways to enforce annulled awards. Judges have become so creative that we need to ask ourselves, do we want that Russian doll where we have an arbitration, an award, a setting aside of going to Court of Appeal, to the Supreme Court, and then we have the enforcement that can also have 3 layers. I mean, it keeps unraveling. And with an annulment, let me get back. First, we think the award is binding. Then we think the annulment decision is binding. And then we're actually back with the court where the annulment decision was not binding, but the award is binding again. But then that can go to the Supreme Court. So it's just, we're losing our minds here. And one, seemingly simple solution is for national legislators to do away with the setting aside for awards that are rendered in international arbitration. Now, so here's my plan that I'm going to part with you. It's the following thing that we need to do for the next 10 years. Obviously, we don't want to think ahead that far, but for the next 10 years, we need to think about these points. We need to engage in stakeholder engagement with national legislators to see how difficult is it to make those little amendments to the setting aside regimes when it comes to international arbitration. And simultaneously, we need to engage with stakeholders of contracting states, so the policymakers, to see if they're willing to discuss a new Treaty 2.0. And then we go back to the experts and the authorities to say, how can we dress up a new Treaty 2.0 based on Article 3 and Article 7. And I just want to say this, I know we've been told by Pete Saunders and our arbitration friends and the unsettled people that this is not possible, but why then do we all find ourselves in Working Group 3, where there are efforts to replace thousands of bilateral investment treaties, efforts to replace multilateral instruments and organizations, and efforts to have this World Court? If that is now all of a sudden considered to be realistic, then I do think it's realistic to at least explore the New York Convention 2.0. And we can give it a new home, maybe even in Mexico. And with that, Julieta, I'm going to give the floor back to you.
Thank you very much, Marikee, for such an excellent presentation, a very bold presentation also. And it's true, the world has changed so much since the last time we saw each other, like 2 years ago. Everything is so different. So why not trying to think again what we already have, the New York Convention. So if you have any questions, the floor is open for you. Antonio Pereda.
I see, exactly. I see Antonio and then Hector. I have a few questions, but I'll defer to them first.
Antonio.
Thank you. Good morning and congratulations for this great presentation. I just want to underline a couple of comments that our speaker made that I think are relevant. I agree with the concept that mediation is the future, and also Marikee said that arbitration should be seen as the last tool, but not the first one, and is the one that works without really a strategy, because you are deferring the result to a third party, and in mediation, the strategy is always in your side. I agree with the concept that the Singapore Convention is a copy of the New York Convention, and in that sense, it's interesting to understand the limits, the interpretations that we will be facing in the future in the case of Mexico when the Singapore Convention is adopted. With respect to sovereignty of the countries, I think that mediation gives us the comfort that the control of the case is always in the hand of the parties. And in that sense, there shouldn't be any sovereign issues because, for example, talking about Pemex will always remain in control in case that is submitted to mediation. And my call is to the arbitrators participating in this interesting conference to give mediation a chance. And I want to underline that always is good time to try mediation. At the beginning of the arbitration, at the middle of the arbitration, at the end of the arbitration, before the arbitration, any time is good to try mediation. And to underline that, in my opinion, nothing is to lose in an arbitration process. You don't put anything in risk. And that's why, in my opinion, the arbitrations should keep in mind always the mediation, and my call is to give a chance to the mediation. And the speaker refers to the mediation process as a process difficult to embrace and that the community is reluctant. Possibly it's interesting to know a little bit more about her view on this on this topic. Why is difficult to embrace? Perhaps the interest of the lawyers are not aligned with the interest of the parties, and we should develop ways to pay well the lawyers that finally resolve the topic without following a full procedure of arbitration. These are some topics that came to my mind after the very good speak by Marika Pulson. Thank you very much, and congratulations again.
Thank you so much. I'm very happy with this feedback because we've really been trying to shed light on mediation for some years now. With we, I mean the stakeholders at my firm. And again, to explain a bit more, these are not lawyers. So these are diplomats, former politicians, those who were in government, and people who have worked a lot both with investors and governments. And they see as the outsiders that mediation is just more suitable. It's more suitable for international trade. Now, I always say there's a Dutch expression, which is where there is a will, there is a way. And what we then started to do is sort of map out the landscape. So we have the Singapore Convention. Do we have mediator trainers? Do we have mediator firms? Do we have those who can assist the parties in the mediation process? And then we went to institutions, to state representatives, and we've also talked with big corporations to understand how they feel about mediation. And obviously mediation has been a topic at conferences. Now, point one, in the international arbitration community, there is hostility, there is reluctance. I think what that is very much is it's the unknown. So most arbitration specialists just don't know about mediation. They come from a background of litigation. So many of them have done litigation before the courts, and then arbitrations is a contentious, is a litigious procedure. And it leads to a judgment in favor of a decision in favor of one, not so much in favor of the other. So it's very much like a judgment and not so much like a mediation advice. So it's maybe also simply put competition. Then what we see with the, let's say, the users in international trade, they say, well, where are the mediators? So one question that has resurfaced many, many times is, who do we appoint? Where is a list? Where is a roster of mediators? We have engaged with, for example, ICSID. ICSID works very hard to promote mediation. They do mediator training. They have rules and institutions or organizations like JAMS. So there's, for example, one consultancy in Washington with leading superstars who mediate. And what is perhaps not known for those outside of the United States, Harvard is very famous for its negotiation project by Fisher and by Uri Fisher, and these are the people who go worldwide and negotiate deals off the grid between states, state to state or state investor. And so these are the people who know mediation inside out. They know what we call third-party amicable assistant settlement. So it's out there. It exists. There are mediators. Mediation exists. It's very much being pushed by international organizations. It's just we need to bring that into the, I think, international arbitration community and create more awareness. And when it comes to, for example, big corporation users, they are reluctant because they say, we don't know how we can enforce it. And that's where we get back to the Singapore Convention. Okay, how can we then do training sessions with the judges so they will know how to apply the Singapore Convention? We need to talk to the legislators to make sure that they implement the Singapore Convention. So there are a lot of moving pieces that all need to move at the same time because it's new. It's old and it's new. This is the irony. Mediation and that type of diplomacy and negotiation existed way before international arbitration. It's just that our modern community of international arbitration specialists is not very familiar with it. And I had the pleasure of working with my colleagues and the people at the Harvard Negotiation Project. And I have learned there's a whole world out there of people who are very, very good at this. So it's now our job to engage in more advocacy. So I hope that answers your question in any way.
Yes, very interesting. And I agree in general with all what you said. Thank you.
Julieta, ¿quieres dirigirlo? ¿Quieres que yo lo, cómo prefieres que lo hagamos?
Sí, retómalo.
Héctor, ¿quieres comentar algo?
Sí, Francisco, muchas gracias. I apologize for not turning on my video, but between my COVID situation and my internet connection, I prioritized my audio. I thank you, Marikee, for your presentation. It was very interesting and very compelling. I fully agree that we should not have fear of change and be fearful of taking on this challenge. At the same time, I'm going to use the word frustrated a lot in this comment because I had the opportunity to participate in the negotiation of the Singapore Convention at UNCITRAL and got frustrated a lot along the process personally. And the reason is, you already mentioned one, and that is why did we use the New York Convention as a blueprint for the Singapore Convention? And that is a fundamental question that was raised at the very beginning before the works even started. This was raised at the Commission. And the only answer we got is that that's the best there is out there. And it was frustrating to see. It's obvious for all of us, at least here, that arbitration is not similar to mediation, and just as an award is a completely different animal than a settlement agreement. So the premise on which the Singapore Convention started was flawed, in my opinion. I do think that the majority of people there were really keen and were really interested in doing the best we all could do with what we have. I mean, what I mean to say is that the intention was always good, to do a good treaty, to do the best we could do. But at the same time, if we look closely at the convention, there's a lot of things, there's a lot of words, phrases that are going to be problematic for the courts to interpret. If we look at the New York Convention and see the problems it created, you outlined some in your comments, and then we look at the Singapore Convention, we can start already to imagine what the courts can do without a proper training and without having full knowledge of the subject. So I think it's very important, as you said, to educate ourselves and every user, every court that has to deal with these issues, to know how to deal with them, how to interpret this treaty. I think that the Singapore Convention goes a long way and do provide, it does provide, in my opinion, something valuable that the states should jump on to foster the use of mediation. I do believe it provides something we didn't have before, but as I said, it's frustrating to see a missed opportunity. Let me put it that way. And that leads me to my final comment, and I would love to hear your view on this. You already mentioned the importance of having the will to change things, no? The Dutch saying you mentioned. And I'm afraid we need will, yes, of course, and we also need the proper speakers, because taking again on the Singapore Convention, the people speaking on behalf of the countries in the majority of cases were not practitioners, or were not fully engaged in mediation theory, at least. And those practitioners that were there in the room, in the alleys, were commenting on, I agree with your views and I think this should be this way, but I'm not allowed to say this publicly because of a policy issue. I'm mandated to speak in this way. A troubling issue was also how the European countries, not all of them, but moved in a block according to policies of the EU. So what I mean by this is we of course need will, but we also need the proper people to speak on these topics. And we have the opportunity to see what's going on in Group 3. And but finally, I'm sorry to take so many minutes. I'm finished. But I would love to hear your view on how do you think we can manage to have the will, but also the proper speakers to create something quite extraordinary and really replace what we already have right now, starting from the institutions, probably, because the institutions were there. The ICC was there, the ICDR was there, but they were silent most of the time, which was unfortunate. So thank you, Marika, again, and congratulations on this compelling presentation.
Thank you. Well, you had me at frustrated. This is always where I have to make a choice right in the moment of, am I going to be a grown-up or am I just going to be Marika? So basically be very Dutch and follow my mother's advice, which is good girls go to heaven and bad girls go everywhere. So if you say, you know, how do we get there? Well, we have to be bad. So I hear you more than you could possibly imagine. The 1958 New York Convention was pretty much drafted by Pete Saunders, who was teaming up with his buddies, Holtzman, Jean-Robert, Rolot. So there were about 4 arbitration specialists in the room, and otherwise it was state delegation. So Ministry of Foreign Affairs sends a person, right? But luckily, Pete Saunders took the lead and drafted the text that is now the New York Convention. I don't know why I always have to go back to Dutch expressions, but they're just golden. So there's another Dutch expression that says the best captains are left ashore. When it comes to the Singapore Convention and the making of the Singapore Convention, there are leading authorities who really know the New York Convention inside out. And Albert Jan Vandenberg was mentored by Pete Saunders and has spent now, I would say, 4 decades working with this treaty. So it's safe to say that he kind of knows, and he could have given detailed guidelines on drafting and would have been willing to, but was not included. And I think I'm being extremely undiplomatic here and probably burning a massive amount of bridges as I speak. But the captains were left standing ashore and not on the actual ship, and now the ship has sailed. Second, it is just very much part of UNCITRAL and any other organ of the United Nations that this is obviously a coming together of state delegations. And this is a matter of politics and bureaucracy of somebody within a government, often the Ministry of Foreign Affairs, sending people over. And then UNCITRAL becomes one of the many items on the list. So sometimes there is somebody at a department of the Ministry of Foreign Affairs who gets an invitation by UNCITRAL and thinks, okay, let me just send 2 juniors. And then you have a room of people, like you say, some who have just received the instruction to make notes, some who have received some talking points. And what sometimes happens is that some countries actually have a arbitration specialist. So we've seen Gabrielle Kaufmann-Köhler representing Switzerland. We have seen some other specialists getting the ticket for a country and attending in that capacity, which has been immensely helpful. Then there are the observers, so the non-state delegations, as you know, you just mentioned them. It's just that it has to be state driven. So this is why it's so complex. But what is so, and this is the word, frustrating, is to say, oh gosh, the New York Convention is the best we have, let's just do a copy paste. That is so unfortunate. It would have cost nothing to just consult with the experts and to say, for this one, let's just change the text XYZ. And you know, it has happened. We are where we are, and now we have to make the best of it. And even the New York Convention was an agreement to disagree. So when people wonder why was it written like this, and this looks pathological, and this doesn't make any sense, well, because there were multiple drafts of text during those 3 weeks in 1958 in New York. And at some point there's a vote, and then you are left with what you have. So it is a political way of coming to a text. It's not for lawyers who work in a document track changes, as you very well know. And so it is a compromise. It's a political compromise, but it's very sad that the lessons learned of the New York Convention were not implemented in the Singapore Convention. So, and I'm very, very frustrated about that. And indeed, with the Working Group 3, we see a lot of the same. And it is so important. It's so important for stakeholders, the arbitral institutions, the ICC, to be heard. And that's where I come back to the we have to be bad. You have to attend. You have to get out there, you have to make the statements, you have to push back, and even on the sidelines. So organize informal events, organize intercessionals with states, organize them with the stakeholders, organize them with the judiciary or with the legislator, and do the roadshows. Now, Francisco and Julieta know all about this with the roadshows that we've been doing. And this now becomes, for the Singapore Convention, it's going to be crucial to do the same. So to have guidelines, to travel or to virtually travel, to engage with legislators, to engage with the judges, to say, now you have the Singapore Convention, we have 60 years of lessons learned, let's just do this, you know, the following way. And as both Francisco and Julieta know, this actually works. Francisco has engaged with judges in Costa Rica, and the outcome was unbelievable. So yes, it's difficult, but it's not impossible. Now, with the fact that the EU acts as a bloc and has talking points, that is something that we see yet again. And so that's why in my little presentation, I really married the political with the law, because that is what we see when it comes to treaty drafting, treaty making, and the use of treaties in the national space. So I agree with you. I am also frustrated, if not even furious, about some of the things that have happened or are happening. We do have to be rebellious. We have to be loud. We have to be the disruptors for change. And now that we do have a Singapore Convention, it is now up to the community to make the best of it. Because as you will have seen, the Singapore Convention is there. There are materials on the UNSTO website, like policy guides for governments as to how do you sign on, how do you implement, etc. But they're very superficial. So states need a lot more than what's on the website. And so, you know, this is the American way. If your government doesn't do it, you have to do it yourself. And so that's where we are now. And really, I wouldn't say the writing is on the wall, because that sounds negative. But mediation is going to happen, and it will be a fixed part of international trade. And what we have is the Singapore Convention, whether we like it or not. So I hope that helps in any way, because the only thing I could really say is that I'm equally frustrated.
Thank you for your comments, Marikee, and thank you, Francisco, for giving me the floor.
Welcome, Hector. Any other questions by anybody? Marikee, while somebody else decides to ask, I've learned that the best thing somebody can do to somebody who has an idea such as yours is to take it seriously. So I'd like to take it seriously and ask you a few questions. And I'm gonna ask them so you can decide how much time you wanna comfort to each one of them. The first one is, what would you respond to people saying the New York Convention works? If you mentioned, if it ain't broke, don't fix it. But coupled with that, not because of complacency, but we have 60 years of experience. We have thousands of decisions interpreting and implementing the convention. And even though there's some unfortunate few, the truth is over, 90% of the cases do work. Or 90% of the cases, the New York Convention works. The second question I would have is, if the pillars are going to be Article 3 and 7, does that mean that you do without Article 5, that awards, there's no reason why awards should ever not be enforced? Third question, blockchain. I think it's ahead of your time, which obviously speaks very, very highly of you, to think of blockchain to do this, or to base the New York Convention 2.0. But my question there is that blockchain is still in Pampers. Most of the economy is not there. There's a lot of concerns about blockchain, because even those who like the idea that we should leave it alone and see how it grows, that's me. And what I've learned about this, and I consider myself to be a neophyte on the topic, but what I've learned is that it's a second type of currency, not state sanctioned, and therefore it's something that it's going to be interesting to see how it grows. But in the meantime, there's many concerns that, for instance, in some parts of the world, that's what organized crime uses to get their ransoms, their payments and to circumvent state limitations. But the bottom line is that most of the world economy is not in blockchains. So if we have a New York Convention 2.0 that is centered in blockchain, what will we do with the rest of the world that's not in blockchain? And finally, would the proposal mean that we would have a New York Convention 2.0 in parallel to New York Convention 1958, or is it doing without the second one? I am putting up in the screen a picture I have of your book. I don't know if everybody else can see it. And when I finished reading your book, just as it was still warm from the press, I remember that this question caught my attention. And I thought it was a great way to finish your book. And I, by the way, sense that you've kept on thinking about it, because I see a lot of this question in your thoughts of today. Does a quilt of provisions of the New York Convention and other treaties and national provisions on arbitration contribute to predictability? I wanted to pick your brain to see if you've thought more about this.
Okay, my brain, there's just fire coming out of my brain right now, and I love this. So question number one, the New York Convention, it works. Well, so if we look at numbers, yes, it does. 60 years, almost 170 contracting states, thousands of decisions. And so the majority of decisions are positive outcomes. So in that sense, yes, it works. But then at the same token, ISDS works, except for, Argentina. I think when you would ask any national judge, does it work? That judge would probably disagree with you, right? That judge will say, well, yeah, wait a second. These are all the questions that I'm confronted with that I cannot answer. So what you see is, yes, there are a lot of cases where the judge grants the enforcement request, but over 60 years, yes, we know a lot, but that also means that lawyers have become very sophisticated or even unscrupulous in using that. So what we see now is that an award that was actually perfectly binding, at this point, judges now, or lawyers acting for the party resisting the enforcement, have found a way to use Article 5 to stop the enforcement. Not because the award wasn't perfectly binding, but because they can find they have a toolbox full of tricks, right? We see a little bit the same in ISDS. That's why it's with Working Group 3. It's the way certain lawyers have used the system. So now what you see in actual enforcement procedures is it's not only Article 5 that's used to stop the enforcement, Article 4. So a party will say, well, that part has not been authenticated here. This has not been certified there. Well, you should have also submitted this translation. And it's no longer good faith. It's no longer practical. It's become playing. It's a game of linguistics, right? Article 5, due process. I mean, there is now a wealth of examples that can be used for lawyers to say there was actually a due process violation. Public policy has become Pandora's box and is unpredictable. So after 60 years, the drafters could not even have imagined the level of abuse, right? The drafters could not even have imagined how many issues of interpretation these national judges are confronted with. And so, yes, the outcome is still that most decisions are the granting of an enforcement request, but we also have to look at how long does it take to get there? How long are these procedures? How costly are these procedures? So what we see with users of arbitration, they say, well, and again, we get back to mediation again. Users of arbitration say, listen, I thought we had opted for arbitration. I have done this whole arbitration. This is what I've paid in lawyers' fees. And now I cannot enforce my award because now I find myself back with the courts, which is where I did not want to be. And now the enforcement procedure is going to take X years and it's going to cost me X. And that's what we see with the investors who come to us, who are saying nobody said that there was going to be a second phase. So again, I go back to theater. You have sort of the Act 1 and Act 2. Act 1 is the arbitration, and Act 2, after the curtain break, is the enforcement. And in big cases, those costs become significant. And so when you look at, let's say, the CFO of a company, that CFO is going to say, well, what is the entire cost of resolving this dispute? And it's about predictability, and it's about something being binding, and then it turns out it's not binding. And then add to that layer of setting aside. So we all know that the minute a tribunal has rendered an award, the successful party will move for the enforcement, and the losing party will move for the setting aside of the award and resisting the enforcement, right? And then we also have the whole ISDS little bucket of we can resist the enforcement under a treaty or whatever. And then so there's always all these multiple parallel pathways that happen after an award is rendered. So that whole idea of this is a mechanism of dispute resolution in international trade has this sort of second phase that comes after. And that's where you go from these arbitrators who are supposedly, specialists and have been appointed by the parties, and it's all based on party autonomy, to these national judges who, as we've seen with all our travels and talking to these judges, they're not specialists of international law. They're not specialists of international arbitration. So yes, I agree that maybe the outcome is that people will say, we've got that treaty, we've had it for so long, most of the decisions are positive, let's just leave it as is. But then if we were to do a survey among judges, but also users in the business community and international trade, I would not be surprised if they would say, you know, we would be happy for you to explore something else. Again, that's my view of maybe knowing too, you know, just seeing the problems. Then, so with Article 3 and 7, so here's the thing with Article 5. Here's where it becomes tricky, and it all depends on what you're going to do with the setting aside regimes, right? So the world is basically divided in the courts of the seat, the lex arbitri, and the court of enforcement. So we're just going to assume that if you opt for an arbitration, let's say in Mexico, that is the seat, and the lex arbitri is also the Mexican law. Okay, so we're not going to have that weird French-German situation. We're just going to have the seat is also the lex arbitri. So what does that mean? That means that the national judges of that country know their laws, right? They are expected to know Mexican arbitration law. So if there are questions of violation due process under the lex arbitri, was there a valid arbitration agreement under the lex arbitri? Was there a violation of the mandate under the lex arbitri? Was the procedure in line with the agreement, composition of the arbitral tribunal in line with the agreement under the lex arbitri? The judges of the seat, so I call that the courts of origin, will know. Now, that's not how the New York Convention works. The New York Convention says, if you want to enforce an award elsewhere, that award is outside of the seat a foreign award. And that's when the New York Convention kicks in. So let's say my client has won an arbitration and has assets in, let's say, 12 countries. So we will move for the enforcement in those 12 other countries, not being the seat. Then you are asking those 12 other courts to look into the lex arbitri, which is not their law. Now, obviously, you have due process and everything's being submitted and la 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 la. But there is something to be said that the courts of the origin of the seat would be much better positioned to look into 5.1 than the courts of enforcement. So that's the part of 5.1 that now that is parked with the courts of enforcement, whereas perhaps logically it should be parked with the courts of the seat. And then we have 5.2, which is public policy. So you kind of ask yourself, and this is now we're going deep into sort of the hypothetical questions of how the world could be. If the courts of the origin, they are presented with the setting aside, yes, and under most national laws, those setting aside grounds are very similar to Article 5. So these courts for the setting aside, the courts of enforcement have to look into valid arbitration agreement, due process, mandate, etc., to see if that was in compliance with the parties' agreement and lex arbitri, and then the outcome will be yes or no. And then it's other courts who in a way are going to be answering the same questions. Why not then just keep that part in the seat? So that's one. And then you park public policy wherever you're going to enforce. So what you could do is what I call a dual convention. You can do two scenarios. One is, okay, fine, you're not going to touch setting aside regimes. Okay, so they will be there. They will be there. Then you can just say, listen, the court of origin is already going to look into all those grounds of Article 5.1 through a setting aside procedure. Those questions are going to be answered by the court of origin because the losing party will move for the setting aside. Why then also have 12 courts of enforcement look at the same questions although they don't know anything about lex arbitrii, why don't you make it 1 stop instead of 2? So that's a thought right there. Like, who would be best positioned to answer, to look into the points under 5.1? Now, 5.2, which is public policy, has become, well, everybody calls it the unruly horse, right, of public policy. After 6 years of case law, I think the jury is out and has said, well, public policy under Article 5.2 is really a very narrow concept of international due process, right? The most fundamental norms of morality and justice, blah, 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 blah. And if you then test it on the case law, it's really just limited to due process. So why not then say, okay, let's just leave that with the countries of enforcement in their national legislation. So there will be many other ways under the procedural laws for those courts to say, wait a second, we have another reason to stop this enforcement. So what my point is with Article 5, it is not so much about the grounds, it's about which court should look into it under which law. And I like those 2 camps of courts of origin and courts of enforcement. Now, how that would have to play out really depends on that first bucket of research, which is the stakeholder engagement with national legislators to see would they or would they not want to abolish setting aside regime. So Albert Jahn did a speech on that, like, should we abolish it? Now, the minute national legislators will say, well, we actually don't like the setting aside regime, then it's not that 1 stop is gone. If there are setting aside regimes, you can say, let's just park Article 5.1 there, we're done. So this is something you need to think about. What are national legislators willing to do? What do they prefer? But if there is a setting aside regime, you know, if you want to limit the Russian doll effect, you should then cancel Article 5.1. And overall, one needs to revisit the idea, why do we have that public policy in there to begin with? And that's the point raised with all these negotiations of treaties. It's not the arbitration specialists who are in the room saying we should have public policy because this is good for the rule of law. It's some representative of a government who is insisting on sovereignty. And if we look at the outcomes of Article 5.2 and public policy, really in sort of the practice of the New York Convention, we have our landmark cases, but ultimately judges have reduced it to something very, very narrow that we can also park elsewhere. So I'm going very far in sort of an abstract thought process, and there are many, the devil is in the detail, and obviously I have not worked those out, but I do think it's worth exploring that engagement with stakeholders to see if there's something there. Now on blockchain, so there is a company created by students of the University of Miami, which is called Samba. And this is blockchain ADR. So I know there is Bitcoin. Bitcoin is something that makes use of blockchain. Blockchain itself is a carrier. So how Martin Hunter visualized it, it's a chain of blocks. But it's a tech carrier that can, yes, it can be a host for Bitcoin, but it can also be a host for arbitration. So what that means is the following. So the ICC in Paris, for example, we discussed it with Alexi Moore at the time, could say, for our institution, so we have websites, right? We can store electronic documents, we can use emails. In addition to having an email server, we will also have a blockchain carrier. And it means that whenever the ICC would have awards, yes, instead of, so let's say I have my award in my computer, I'm going really to dummies for IT because that's how I understand it myself. So let's say I have my award electronically in my computer, right? And then the ICC will have a server where all these awards are stored in electronic folders, right? Now, instead of storing those awards in these electronic folders, they are secured in this blockchain carrier. Arbitration clauses equally can be stored there. And then what can happen is those who would have to have access to those awards get a uniquely encrypted key that allows only them to access that award. Now, why is this really better than an email or your folders on your computer? Is that it's almost impossible to lose that data or to tamper with that data. So, and this is me, my head explodes while I try to explain. They have explained all of this to me. So, what is the great thing about a blockchain server is that it's much more advanced and secure and reliable than the servers that institutions have today. Now, I fully agree with you. Not all countries are created equal in terms of being able to facilitate all of this. And one caveat is we then met with engineers at the University of Sao Paulo who said, well, wait a second, the cost of apparently the energy cost that goes with blockchain might be more expensive than the actual cost of hard copies. And so again, this is something where we need to do more research. But when we presented this concept, and what you can even do is that the whole arbitration can make use of blockchain. So what happens is we have our arbitration, right? So you have the institution, you have the arbitrators, you have the parties, you have the council. And then, as you know, the statements of claim and defense and this and that are being submitted to the institution, right? We all remember the hard copies of the courier coming by with a truckload of the 500-page statements and all the hundreds of exhibits and all the boxes. Now it's also available electronically. So the next step would be that it would actually be available on the blockchain, which means you all get your own virtual key, so to speak, and that's how you can access an exhibit. And apparently it's more secure. So what these engineers asked us, so you have your documents delivered by a courier. So let's say DHL. So yeah. He said, that's not necessarily secure. No, okay. So you have an award, can that be sent to you, let's say by the institute or by a tribunal? Can it be shared through email? Yeah, I think so. So the email is far from secure. So what they try to explain to us is the blockchain is more secure, but then there's the cost. So yes, it's very early. I think Samba is the only group out there right now that is sort of combining blockchain with ADR. And I agree with you, there are many questions that are left unanswered. One of them is would it be available for all institutions? What is the cost? And is it in fact more expensive than paper? So that's blockchain. And then the New York Convention 2.0 and the 1958 Convention and the cherry picking. Now, the cherry picking of Article 7, and I had that in my book. I studied all the drafting history on Article 7. The question is can you mix and match? Can you say, okay, for Article 2, I'm going to opt out and go something based on UNCITRAL, and then for the enforcement, I'm going to go step back into the New York Convention? Yeah, because these are two different actions. But then what we've seen in certain cases is that council tries to kind of mix and match a little bit. So I'm going to take a bit of Article 4, I'm going to take this out. Obviously, you cannot do that. My view is that is taking it to the next level. But Article 7 is drafted in a pro, not bias, but pro-enforcement attitude, right? So whatever favors enforcement should be possible under Article 7. Now that is the more favorable provision, so that if there is a national law or another treaty like the European Convention that is better for the enforcement, then that is what you should opt for. Now, I think that if one looks at the drafting history of the New York Convention, cherry picking is not possible. But again, this is me giving a very technical interpretation of the New York Convention, where some judges will say, well, I'm just going to look at the text. So again, you have to look locally. Now, when it comes to how would this all work together, it's in fact the same way of how they try to address how could the New York Convention work alongside the Geneva Conventions, because now we see almost 170 states sign on to the New York Convention, so the question of applicability of the Geneva Convention is almost moot, although, for example, in India, the Geneva Convention apparently still applies. So there is what has been addressed is retroactivity, so retroactive application of treaties, and would one treaty supersede the other? And so the New York Convention, the drafters of the New York Convention addressed that with respect to the Geneva Conventions. And so what would have to happen with the New York Convention 2.0 is that you have to put in one of those provisions based on the Vienna Convention of Law of Treaties is those signing on, for example, to the New York Convention, for those, it will supersede the New York Convention, or countries can add their own legislation to that extent. So it's like the sunset clauses. Now, this is the point that Pete Saunders raised, Francisco, which is there are already, well, at the time, 2012, he said there are already so many states signed on to the New York Convention. It's going to be absolutely impossible for that all those states would also sign on to a new New York Convention. So now what we are looking at, so we're looking at 170 states signing on to New York Convention 2.0. Yeah, maybe I'm living in La La Land, but let's go back to UNCITRAL. If it's so hard for 170 states to even think about a New York Convention 2.0, why are we even talking about replacing 3,000 bilateral investment treaties? So, you know, and the compatibility with ICSID and the compatibility with PCA. So if somehow that can now be the mandate of UNCITRAL, then I don't see why we cannot go back to UNCITRAL and say, well, if you're going to do this, then you can also look at New York Convention 2.0. So this is me being a little bit of a nasty girl, maybe, but I remain stubborn, and I still think we should give it a try. I hope this answered all your questions, and I took far too long, but they were quite intense questions. So to put it.
You did not take too long. I very much appreciate the detail you went into. I'm not sure if you're thinking of writing an article, but I think it's worth putting your idea in paper so that we can analyze it with a microscope, because it's a curious fact that the two persons have written the two most important books on the New York Convention jointly believe we should do without the New York Convention. So this is just to serve as an encouragement. If you write it, many of us would read it. And having said that, I don't know if anybody else has a question, would like to ask Marika something. I know we're over time, but does anybody want to ask Marika something? Well, Marika, it's been a fabulous session. I received tons of Whats already saying what a great session it was. I received some emails of people saying they really wanted to be here, but they couldn't because of work. So I observed that the session has been recorded. Would it be acceptable to you that I share it with people who express interest in the session?
Be my guest. I would be very happy to.
Okay. Well, thank you for being here with Mexico all the way from Bahrain. Thank you for the effort you did and your excellent presentation. And I thank everybody else on behalf of the Mexican Bar Association Commission on Arbitration for being here in this session.
Thank you.
Thank you, Marikee. Bye-bye.
Bye.
Bye.